There was some really good information that was in there, and I didn't even realize that your traffic seminar that you had from 2009 had all the information that was listed in it. So I went ahead and purchased that yesterday. I'm still waiting for the link to come through so I can download it. And I figured that I think my biggest problem I'm having right now is just putting everything in line in order of how I should be operating. So I figure the traffic seminar should get me a chain of events in the order they should take place. Does that sound appropriate or correct?
The thing is it's not a matter. There is no specific order unless what you're trying to learn now requires information you don't yet have in order to understand it. So when you find yourself looking at something and going, well, what does this mean? I understand what it's saying here, but I don't know what this word or this thing or this part of it means. That means you're missing information, right?
Correct.
Which means you need to branch off and go locate that information before you can fully understand what you're currently reading.
Yes.
So it's a trial and error process. There is no step by step by step, because there will always be an encounter with new, not yet understood information. That's the nature of a statute, because a word in one statute can mean something else in another statute, even when they're dealing with the same area of law. You can never assume that you understand what you're reading just because you've seen it before. You need to verify. For example, does the term person here in this statute have a different source definition than the way I've been reading it over there in that set of statutes? And if it does, what did they change it to? That's not something anyone can tell you up front, because every statute will do it different. Okay, understand something about challenging jurisdiction. You need to have a specific basis for challenging the jurisdiction of the court. Okay? Those exist in three areas. Okay?
Okay.
They exist over the offense itself. For instance, low-level courts don't have jurisdiction over felonies. They don't have jurisdiction, for instance, municipal courts and JP courts do not have jurisdiction over anything other than Class C offenses. They don't have any jurisdiction to try. Now, I distinguish between try and find probable cause. Two different things. They cannot adjudicate a Class A, a Class B misdemeanor, or any kind of felony. They can only adjudicate Class C fine-only offenses in Texas. Now, that can change from state to state. So, what jurisdiction of the offense is the court granted by statute? Then there is personal jurisdiction. Personal jurisdiction can be attacked in two ways, or at least normally in two ways. The first is that you are not a person subject to the jurisdiction of the statute because either A, you're not in the state to have committed the offense and therefore not within the jurisdiction of its courts, or B, they are misapplying the law to you as a person who is not subject to that law versus someone who is. So there's misapplication of law, and there is a misapplication of venue jurisdiction. You were never in the venue to have committed the offense, and therefore the court lacks personal jurisdiction to try you for the offense. That goes to personal jurisdiction. Okay, the third is venue itself. All right? The offense didn't occur in the state where it was, or where they're trying to try it, or the county where they're trying to try it, or the municipality where they're trying to try it, or the venue is improper because of a lack of jurisdiction over the offense. In other words, the court lacks venue jurisdiction because it doesn't have subject matter jurisdiction over felonies or Class A or B misdemeanors. Okay, so those are the three areas of jurisdiction and the various ways you challenge each of them. You can challenge more than one if you've got a legal basis to do so.
Got it.
But
So,
you always start with the one that has the strongest legal support for the argument you're trying to make.
makes sense. And in my case now, you having given that, it appears to me that I only have one to challenge, and that would be personal, as in being not the person that the regulatory.
No, not a class of person to whom they're trying to apply the statute.
Okay, not a class of person as
right.
either.
You are not a member of the class to whom the statute they're trying to use attaches. It doesn't apply to you because you are not one of these persons defined by that class.
Well, it wasn't.
That's normally them trying to classify you as a driver or an operator of a motor vehicle.
Okay.
They have yet to establish that you are actually a person in one of those two classes operating a device that falls within that class. They're just assuming those facts. They're not doing anything to prove them. You need to challenge the assumption. There is no evidence being presented that I fall within the class of person that is subject to this regulatory statute, and there is nothing that shows that my automobile was being used as a class of vehicle subject to this regulatory statute. Right. They are not offering any proof of that assertion. And the problem for that is a definitive element of the offense. It must be a motor vehicle subject to that statute, and you must be an operator or a person in control of that motor vehicle in order to be subject to that statute.
Right.
They're just assuming those elements to be true. They're not proving them to be true. So what proof are they offering? This is where giving them your license at the time counts against you.
Correct.
The presentation of that license is an assertion that that license applies. If the license applies, you're a driver. If you're a driver, then the assumption is that you're in control of a motor vehicle because you also produced insurance and registration applicable to motor vehicles.
Okay. So
that's the problem with the way they're doing this. They're compelling you to produce evidence against yourself to prove the element of the offense is against you instead of them being required to prove it. They just get to assume it. And from where I've been learned about law and everything they talk about in learning law, when it comes to being charged with a crime, they can't assume jack shit. Nor can they compel you to provide that information to be used against you in a court of law. And yet they do it every single fucking day. And yet no one's thought to go, wait a minute, you're charging me with a crime. Despite the fact it's not truly a crime, you're prosecuting it that way. When you invoke it as a crime, then I invoke certain rights that you can't delete just because you want to sort of qualify the classification of criminal conduct. Either I have these rights in a criminal case or I do not. Which is it? And if you're saying this isn't truly a criminal case, then you're saying you don't have any proper authority to try me in the first fucking place because you don't have an actual victim. Because a true crime requires corpus delicti, a body of the crime. And for there to be a body of the crime, there must be a victim who suffered because of the commission of that crime. And it cannot be the state, which is an intangible legal fiction.
Question relative to jurisdictional challenge. If the charging instrument itself is lacking in the proper configuration, and if the charging instrument was not meant to be provided by their own criminal code, and I'll explain in a minute, are those merit-based arguments or would those be jurisdictional-based arguments?
How can they file a complaint against somebody for the commission of an offense and yet not have to have a complaint filed?
I agree with you on that, but I don't know whether that's considered as jurisdictional or if that would be considered as merit-based.
Well, what invests the courts in your area? What invests them with jurisdiction according to your constitution, your state constitution, and your state law? What invests a court with jurisdiction of the cause? Here in Texas, it's very clearly spelled out. An indictment or information are the only two instruments that can invest a court with jurisdiction of a cause. A complaint cannot do it, yet they do it all the time.
Yep,
But that's a violation of due process.
Absolutely.
Because it's a violation of your rights as protected and created in this particular case. It's a limitation created upon the courts, not upon the people. We, the people, told the court, you do not get jurisdiction over us unless one of these two things has been filed. And then the court created something entirely out of its own volition to allow a complaint to do what the Constitution says no complaint can do.
Yeah, and they'll argue and argue and argue. Well, Judge,
they'll try to argue that the Code of Criminal Procedure says they can do it, and the case law based on the Code of Criminal Procedure says they can do it. But what they will not do is look at the goddamn Constitution to say what you're saying about the code and about the case law is in direct conflict with the Constitution, which is the one thing you morons cannot violate and be allowed to get away with.
Well, and involved with the Constitution as well. So based off of those videos that I mentioned to you that I'd watched over the past week with Cameron and Bad Wolf, coming across and looking into my state constitutions more clearly as well. And one of the things that I run into is that it says is that no person shall be tried in any instance of law without access to a jury, yet they deny access to a jury in the district courts, and their own appellate courts say that it's okay because you can appeal it as a trial de novo to the circuit court if you choose to. But now you've got to pay for your trial in the circuit court in the second instance. And in the Constitution, it doesn't say you have the right to trial by jury is inviolate.
Right. They try to create layers the Constitution doesn't authorize. They're trying to create layers in order to generate money. This is their way of generating revenue they're not entitled to.
Yeah.
If they're prosecuting you, okay, they can't charge you to defend yourself. You understand that, right?
I do believe and I do understand that.
We're going to accuse you of a crime, and then we're going to force you to pay us a fee for prosecuting you. Otherwise, you're automatically guilty, and that's the end of it. What's wrong with this picture?
Absolutely. So then
what you're actually talking about, however, I think you've got it worded incorrectly. They do basically the same thing here. They try you in a court of no record and then force you to file an appeal bond in order to have a review by trial de novo in order to get to the court de novo.
Yes, that's exactly how it is here.
Okay? That's the same thing they try to do here. But again, the Code of Criminal Procedure says they cannot have a court of no record. At least not the way they're defining a court of no record.
Well,
in my case, they said that the court of no record, the statutes and the constitutions don't apply in there.
Well, and that's
which
the other
is
thing
absolute
too,
bullshit.
is if you look in the Black's Law at court of record, the definition, and then you take a court of not record, which is in Black's Law, 4th edition, and it says a court not of record does not have the ability to fine or imprison. And they're absolutely fining and imprisoning
Exactly.
from a court of no record.
Right. These are the courts that have gone, and your legislators that have gone completely rogue against the population in the name of revenue generation.
So to bring...
But here's the thing.
Okay.
Don't cite Black's Law as the source for that. Is there a Supreme Court case attached to that definition in Black's Law?
I believe there is. I'll look it up while
Then you get a copy of the Supreme Court case and you cite that instead. You never, ever cite the legal dictionary. You cite the court case that created the definition that exists in the legal dictionary.
And then do I back that with the Black's Law definition as well?
No, you do not. What part of this did I not just clearly spell out for you? You never ever cite Black's Law as the authority.
Roger, I've heard you
say
use Black's
the
Law.
The case of Black versus State of Maryland, the court ruled the following. This ruling created the definition in Black's Law for the term whatever, court of record, and defined it as blah, blah, blah. But you're citing the court case that way, not Black's Law as the authority.
Roger on that. The reason I believed otherwise was because when you define prima facie in some of your previous videos, you talk about using the definition from Black's Law for the word prima facie. So that's why I assumed.
Because Black's Law will almost always give you the court case.
Okay.
Okay? When I'm citing the legal dictionary, I'm doing it for the purpose of discussion, not for building briefs.
Okay. Got it.
Okay? If I build a brief, if there is a court case associated with the definition, then that's what I use. If there isn't a court case, I try to do the research to find out where that definition came from so I can find the court case.
Okay. Very good.
But Black's Law or any other legal dictionary is not authoritative. Ever. And you have to be real careful. If there is a court case, you need to make damn sure it's a United States Supreme Court case, or at the very least, it is a circuit court case for the circuit in which you are located.
Okay.
Because that's the only way the court case will be authoritative where you're at, is if it was United States Supreme Court, because that's applicable everywhere to everybody, or it was a term defined by a controlling court case in the circuit you live in.
Okay.
Otherwise, it's advisory.
Persuasive being the same as advisory?
Correct.
Okay.
The court can take it under advisement that this is the legal meaning according to the Fifth Circuit, but if you're in the Ninth Circuit, they can take it or leave it.
And then last question. So as I mentioned, I had ordered the traffic seminar from 2009. What all comes in that? What am I going to be getting?
You're going to get the original book. You're going to get 400 plus legal pleadings that I wrote when I first started this, and that I've updated up to the last time I did updates on them. And then a shit ton of legal research and other information. 60 gigabytes or so compressed.
Wow.
Well, since those documents were originally released, as far as Texas statutes and law goes, those have changed. But again, they're still close enough that you can find them using the AI engines for your particular state. If you find something that's worded similarly.
In Arkansas, so everything that you put out, I have to take and look for the conversions into Arkansas.
Yeah.
How long does it take a judge to normally certify a pretrial record?
That's hard to say.
Okay.
Because it will vary from judge to judge. There's, as far as I know, the county courts at law, they have a 60-day time frame to rule on motions. I don't know what they have to certify a court record or a proceeding record or anything like that. Okay. Now, if you're talking about a record for the purpose of appeal, then the rules of appellate procedure should lay out the timeline they must comply with in order for you to make a timely appeal. Because you're required to have everything done within a certain amount of time at the appellate court level above them. And you can't do that without the stuff the lower court you just came from is supposed to have.
Like you said, I have an appeals that is being moved over from the lower court, tribunal, small claims, to the appeals court, and that's in process. But when they moved it over to the appeals court, they put it under eviction. So I wrote, just to make it on record, I wrote a notice to the appeals court that they had put this in classification eviction. It has nothing to do with eviction. And the case hasn't even been technically, I guess, physically moved over. But then I asked for a stay of like the judgment of the lower tribunal of the $2,000, and I got a denial letter from the court that signed by the appeals clerk that they denied it. But the question is, they denied it under this eviction classification. It has nothing to do with eviction at all. So it went through, supposedly, the court consists of 13 judges, and not any 13 judges could figure out that it was in the wrong classification and it had nothing to do with evictions.
Well, the judges don't see it till the clerks have done their thing with it.
Well, I don't know what their thing it done with it means. It said that it was denied by the court.
The reclassification was denied by the court?
No, the stay of the judgment.
Okay, and I thought we talked about this the last time you brought this up. And I thought we discussed why they would have been proper to do that in this case. Did we not do that?
No. I mentioned that this is when it appeals, but I never mentioned this because it never happened.
Well, I distinctly remember you bringing up the eviction classification in last week's class.
I didn't attend last week's class.
Well, then the week before that.
No, that didn't happen a week before that.
Does anyone else recall hearing this story before?
I don't recall it on the eviction aspect of the case. When did the eviction aspect of the case, when did this happen, Sandra? You got to give us a little bit more in the way of details.
It just the eviction just came just last. Let's see, today is Monday. The denial on Monday.
Oh, wait a minute. I take that back. You sent me an email on this, didn't you?
Exactly.
I responded back to the email on this.
Oh, I didn't get any response. Well, yes, I did just send it. So it's current. I mean, it's current within a couple of days. Now, I have since got it fixed. So it is under small claims now. So that's fixed. I am working with the clerk of court on both the appeals and the small claims tribunal as the information is being sent to the appeals court.
All right. Well, again, I don't know what it is you're expecting me to tell you about the reclassification. If they've got the classification wrong, they're going to realize that at some point.
No, they didn't realize it at some point. I did, because I'm on top of it. But let
me change my adjective then. They're going to recognize they've done it at some point.
Yeah, they are, because I made a stink about it.
Okay. Well, until they respond to it, what is it you're wanting me to tell you about it? They responded to the reclassification issue?
Yes, it's fixed.
Okay. And then what did they say they would be doing since it's fixed?
Well, they said nothing other than it is now in the proper category. Because I had them fix it.
Okay, well then that's the answer I was looking for.
Right. So, well, the idea is I think it's for just a comment to the court that nobody looks at these documents at all. I mean, it was just I sent in a stay of execution, and they automatically denied it without even looking at it. And so they couldn't have looked at it because it had nothing to do with the case at hand. I think that's the comment.
Well, why are you asking for a stay of execution when it's an appeal? The whole purpose of the appeal is to stay the execution of the judgment for the purpose of the appeal.
Yes, that is true. But
then why would you file a separate...
Because courts don't work correctly unless you put it in their faces. If not, they will trample over you and they'll say, well, you never asked for a stay. And I learned from no matter what, as long as you at least put it in the record, right? You have some kind
That's
of...
if a stay is required because you're doing something that's not an appeal of the judgment. Or if you're doing something where the process is allowed to move forward while the appeal is ongoing. There are certain things that do that. Criminal cases, for instance. In some cases, you will be remanded to jail while your appeal is ongoing, like if you've been charged with murder. You will go to jail until your appeal has been heard. Okay? You don't get to stay out just because you appealed. In other cases, everything stops while the appeal is ongoing, and you're out and doing your thing until the appeal's been completed. It varies depending upon the type of case.
Well, that's good to know, because at least I've got it in there, and people have, like I said, everybody's aware of my case now, which is of course.
But here's the thing: you don't just file stuff to file stuff because you think you might need to. You need to understand the process and what's required, because whatever you file, and you file a bunch of crap that doesn't need to be filed, you're going to piss somebody off. They're going to be going, what the hell is this person doing? They don't know what they're doing, obviously. But why are they doing this? What is this filed for? Well, this is an appeal. You don't need that. Well, this is an appeal. You don't need that either. This is an appeal. Why are you filing this motion? That's not the kind of motion that applies on an appeal, et cetera, et cetera, et cetera. You understand?
Yes.
You need to understand the process and the rules that go with it.
Got it. That's the reason why I'm here. I also am.
All of that's not something I'm going to be able to teach you in the here and now in every class. This is why we talk about stuff, and then you go read and study.
Yeah, actually, I am reading and studying, because, like you said, I'm
not saying you aren't. I'm just saying this class will not teach you in 2 hours everything you need to know for any given case.
Oh yeah, I know that. Believe me, right? There's every nuance, every guy. You have to look out for so much. Yes, I know. It's just that this course I took, because you're actually quite smart and articulate and really on point on this stuff, and it keeps my head clear. And also too, I get to connect with people. It is over $2,000. It's a learning in process. It's a confidence building. The next one, if anything crops up, I'll be even stronger the next time.
Well, that's supposed to be the goal of it, yes.
But I'm going to reassure, right, that if, well, you didn't write a stay, so you have to pay this, because it's been ordered for me in the lower tribunal to pay these people the $2,000 that I was awarded from it being fraud. And also, too, I did, like I said, I did get the authorizing statement from the Department of Consumer Services and Agriculture and Consumer Services that said that they should not have did any kind of car repair. And I did get, because I work with the subpoena, I did get because they perjured themselves in court, and they said that I pulled back a credit card. The money, I paid them, and then I pulled it back the same day with the credit card. That's false. That did not happen. I paid with a debit card, and it took 3 months for the bank fraudulent case to figure out that they had no license and they had no bank that was supportive of their car dealership, and I was refunded the money back after 3 months. And so I subpoenaed that dispute from the bank, because the bank did give me back the money and they gave me the final resolution. But what they didn't give me is that the car dealership responded back to the fraud division, and that is a direct perjury of what they said under oath in the small claims court, where they said that their statement was that I had paid them the $2,000 through a credit card.
Okay, wait. Is this the car case again?
Yes,
that's the one you're ongoing with?
Yes, I pushed it to appeals.
Okay.
And it's in appeals now, and I got to get a subpoena of that information. If you're a pro se, you have to go through the clerk of court. And I talked to the clerk of court, and she says that right now, that is true. I just need to fill out properly the subpoena, and she would serve it on the bank to get that information about how the auto dealership did respond to the fraud dispute. It wasn't that I just paid the money and then snatched it back, which is impossible to do.
Okay.
And I don't know what I'm going to do with that, because, like I said, that would be, and I have the transcripts that they specifically said under oath that their version of what happened was happened, and that is factually not happened. That happened over a 3-month period, and they responded back to it. That means that they perjured themselves under court. I don't know what to do with that afterwards, but at least I have it.
Jane, I see you're here. How did your case pan out? Or has it yet?
I just put in the chat that they're trying to dismiss my appeal. They're dismissing the prosecution, so they want to get rid of the appeal, but they want me to agree to it, and I'm saying no.
They want to dismiss the appeal on what grounds?
On that they're dismissing the prosecution.
Of you?
Yeah, they're dismissing. He sent sent me an order from the judge that they dismissed the prosecution, but he wants me to agree that the appeal is moot now, so that they can tell the appeals court that that I agree. But I'm not going to. I've told them I'm not going to agree to that. I want the thing to be ruled on by the Fifth Court of Appeals. You know.
Well, but that's the thing. The Court of Appeals is, if they dismiss the case, did you have to pay any money for this so far?
No, it's a habeas corpus. It's the appeal is for the denial of the habeas corpus from the county court.
Okay.
And my appeal brief was,
okay. Well, clarify something for me. Which case are we talking about?
About the cat case, feeding the cats.
Okay.
Well, the appeal brief made them to where
back up. Catch us up. You haven't been in class since before you went to trial on the cat case.
Mm-hmm.
So, you went to the municipal court. They found you guilty, I assume.
No, they did not. I filed a pre-trial writ of habeas corpus and challenging the jurisdiction of the ordinance and the complaint, and the complaint being insufficient.
Okay.
And unlawful.
And then they try. That's the case they're trying to dismiss.
That whenever that's the case they're trying to dismiss, because after I filed the habeas, and then the first court denied it, then I filed my appeal brief on February the 12th or whatever it was. That they're supposed to respond by Monday, but I just got this email saying they're going to dismiss the prosecution. That they want me to agree that the appeal is moot, but if the appeals court decides it's moot, then that's down on them. I'm not going to let the city of Irving decide that it's moot.
All right, that's fine. Now, which court did you do the first habeas appeal to?
To Dallas County Criminal Court 1.
County Court at Law 1?
The same lady, Kristen Wade, at Dallas County Criminal Appeals Court 1.
And she denied it on what grounds?
She didn't give it. She just said that no merit found. She didn't really give it. She's not ever going to agree to anything like or side with somebody. She's going to let the Fifth decide whatever they want to do with the jurisdictional challenge.
Then what you need to do is, well, you've already filed it, so it doesn't matter. But what you should have done was go after her for abuse of discretion and judicial error.
Well, I haven't gotten that far yet.
She refused to address the issue in order to pawn it off on the appellate court. She had a legal duty as a neutral magistrate to make a finding one way or the other. Okay? And to explain it, but she didn't.
No, she didn't. But I don't want it to get dismissed in the Fifth, because that's, they could actually publish the opinion. They could, they might set precedents or whatever. But my appeal brief was bulletproof. Just no doubt about it. So, and that's the reason why they don't want to respond. But in his request, and even in the order from the judge, it doesn't say anything about being dismissed with prejudice or anything like that, or even about the other case.
Right, and that's the thing. The lack of it being dismissed with prejudice is the other problem.
Yeah. So I'm saying no go. And, they need to present the motion they're trying to do, the mootness or whatever, to the appeals court and see what they say. This is going to get them probably out of it being ruled on as far as my motion, which is messed up, because it's really unconstitutional what they're trying to do. So,
you said Fifth Court of Appeals.
Yes, the Fifth District. My appeal brief is before them right now.
Okay.
I sent you the brief.
If you have, I haven't seen it, unless you sent it in the last day or so.
No, I sent it in the last February 12th, as soon as I filed it. I can send it again.
Yeah, I don't have you in the email list here. Let's see.
Well, I've been getting emails from you.
The appellate brief with appendices,
Yeah, that's it.
525 1641 CR.
Yeah, that's it.
Okay. Yeah, it's buried in the list of shit that I've not seen here.
But I mean, there's no way that they could combat. You know, there's no argument they can come up with, because I went ahead and argued what they were gonna, or I went ahead and shut down what they were gonna argue before they had a chance to. In my issue 2. But after all this work, if they think I'm just going to let it go, just go away quietly, they got another thing coming.
Well, there's nothing wrong with trying to force the court to rule on it. If you have the opportunity to do so, I sure as hell would. I wouldn't take this as a free win. I would take this as a chance to shut them down permanently.
That's what I want to do.
Can you guys explain? I mean, I'm trying to catch on what you're saying about why why you don't want to dismiss, because I don't understand. Just so I have some understand.
Because my appeal brief to the denial of the writ of habeas corpus, it shows the court, and I mean, it's bulletproof. You can't. Irving cannot respond to it, and when they're supposed to respond to it by Monday. Well, they have no response, because in my appeal brief, I addressed everything that they would try to come up with to justify the prosecution. But this is this month, it's been a whole year that I've been compelled to go to court and be in a prosecution. You know.
Did you ever file a motion for speedy trial?
No, I didn't. I never did a speedy trial.
Okay.
You know, they set trial for January the 6th, and but my appeal was already pending, so they were still justifying or whatever their jurisdiction when they had none. That was part of the restraint that I approved to the appeals court. So I want the appeals court to rule on my motion, because there's a challenge to the jurisdiction, challenge to the unlawful complaint. They need to rule on that. That's why I don't want it to be dismissed.
Yeah, and that's understandable, because the municipality will keep getting away with this bullshit as long as somebody doesn't get a ruling that tells them they can't.
Right, and they're charging other people with the same stuff. They don't have the authority at all to create criminal laws that has not already been created by the state.
Correct.
You know, if it's something that the state has already made criminal, then they might be able to get away with charging somebody. But whenever they're coming up with their own criminal offenses, municipalities cannot do that.
No, they can't create law. That's my whole point.
Yeah.
They can create an ordinance that is backed by a state law, and it's limited to exactly what the state law itself is limited to.
Right.
But they cannot create law out of thin fucking air as an ordinance.
That's what they've tried to do. I mean, that's what they've done. And, all these they don't want all these prosecutions to get, and it's not just saying that they will, because nobody really gives a rat's butt. They get a citation, they go down and pay it and be done with it. You know, nobody would probably even know that this happened, my case, but Irving doesn't not want this case to be published, especially if they get a, adverse ruling or whatever.
No, because Irving's gotten adverse rulings on a lot of this shit before.
Yeah.
Well, Jane, another thing involved in it too is once you win this, if you get what you're looking for, then you could contact some sort of papers or something like that, even if it's like if the Dallas Observer is still around or some stuff like that. Mm-hmm. Boston's got a paper like that. See, well,
her better bet would be to publicize a lawsuit for malicious prosecution.
Oh, I'm going to do the 1983 civil
no
rights liability.
Listen carefully, okay? You can literally sue them twice, but you have to be very, very careful to differentiate the claims you make between state claims and federal claims.
Mhm.
You can sue them for violations of the state constitution and state law. But in order to do that, you must avoid any and all claims that invoke anything that is federally protected only. Okay?
Mhm.
You can't cite federal protections. You can't cite 4th, 5th, 14th, none of it. You've got to stick strictly with the state constitutional protections and the state law protections to sue them only in the state. And if they attempt to move it to the Fed, then you can say you can object to the attempt to move it because no federal claims are made. The federal court lacks jurisdiction to hear it. And then when you send it to the Fed, that's a separate suit under a separate jurisdiction for a separate set of offenses.
Mhm.
That way you get to sue them twice.
Well, under their, I can't find any cases whatsoever where anybody has come out and won whenever they are trying to sue for, like, a prosecutor for.
You're
like,
right. You can't sue the prosecutor, but you
Or-
can damn sure sue the animal control officer, their supervisor, and their agency, and the municipality for failure to train and control their employees.
Well, I was going to sue the municipality.
You can sue the individual city council members for enacting an ordinance pretending that they created a law that they knew they couldn't create under the state constitution. They had no authority to do that. Those are the people you can go after.
Yeah.
But you can't sue. But here's the other thing. What you're forgetting here is a city attorney is not a protected prosecutor. They are not elected. They have no prosecutorial immunity like a county or district attorney or the attorney general has.
Right.
They are a fucking corporate employee. And that's how you need to frame them when you sue them for malicious prosecution. They're not a prosecutor. They have no authority from the state constitution to prosecute in the name of the state. Therefore, they have no prosecutorial immunity. None's given by any statute. None. So where would they get it?
I don't know.
They're not elected. They have no immunity. They are fucking corporate counsel. Period. So the reason why you've never seen a prosecutor successfully sued, and that's not actually true, there has been. Anderson over in Williamson County for sending Michael Mortensen to prison for 25 years. Hence the Michael Mortensen Act.
Yeah, the Michael Morton Act.
He
Yeah,
sued Anderson for what he did as the prosecutor, for fabricating evidence and withholding evidence.
Right.
Okay? But here, he was an elected district attorney. Normally, he would have been protected, but he couldn't violate those duties and still be clothed with that authority.
So kind of in my case, where they're denying using 39.14D, they lose that protection when they continuously, knowingly and willfully misapply and misinterpret.
That is correct.
statute.
City attorneys are not immune from suit. There is no case that says they are. If there is, I sure as shit haven't been able to find it.
Are there any cases where they have been sued and
No one thinks they can sue them, Jane. I just told you that. Everyone thinks they're covered by the same immunity that an elected prosecutor gets, and they're not.
But even the elected prosecutor, once they fucked up, they're still not immune anymore.
Once they've acted outside of their authority as a prosecutor, they don't have any coverage either.
That's right.
Just like a judge doesn't have any if you can ever separate them from their judicial function. If you separate them from judicial function, they are just as able to be sued as anybody else. But a city attorney is not elected. They're not even fucking appointed. They're hired by the city manager to act as corporate counsel. They're a private fucking attorney. They have no fucking immunity because the Constitution does not give them any authority to prosecute in the name of the state. None. They did that via statute. And the statute is a violation of the Constitution for that reason, because the power to prosecute in the name of the state is a constitutionally delegated power pursuant Article 5, Section 21 and or 12.
Yeah.
This is the whole reason why I've got that 78-page constitutional challenge to city attorneys prosecuting cases. Because they flat out have no legal authority other than what was Chapter 45 for doing it. And Chapter 45 itself is a direct violation of Article 5, Section 21. What was 45.201 and is now 45A.105. They are unconstitutional on their face as a direct violation of Article 5, Section 21. And if you go looking through the Code of Criminal Procedure, every single place where the phrase attorney for the state is found, every single place, the only attorneys identified by the statute is the county attorney, the district attorney, and the attorney general, or a special prosecutor appointed to act in one of their steads.
Right.
That's it. City attorney is never mentioned. Ever. In fact, the new 45A specifically says that a city attorney is not and never ever will be an attorney for the state.
It does say that?
It does say that. So right there, they're admitting, hey, they don't really have any actual authority. One of these days, somebody's going to realize that and challenge it. Well, I'm trying to tell you to do that.
Well, I can try it. I just know that every time.
Well, remember, all you have to do is frame her as private corporate counsel. She is not an elected prosecutor. She was never vested with that jurisdiction to prosecute in the name of the state pursuant Article 5, Section 21 of the Texas Constitution. And therefore, 45A.105, I think it's B or C is the subsection, is unconstitutional on its face for attempting to redelegate a constitutionally delegated power to a person who has no authority to receive it and exercise it. Period. The legislature cannot redelegate that power to that functionary because the Constitution gave it only to the county and district attorneys. That's it. It didn't actually give it even to the attorney general to prosecute criminal cases. It only gave it to the county and district attorneys. Now, who doesn't believe me? Who thinks I got it wrong? Who wants to just argue about it for the hell of it?
Cities aren't the government. We only have state and federal.
No, cities are government. They're just not the government they think they are.
Right. They're acting as, like, it's been a while. They're acting as government, but they're not government. We only have a state and a federal.
They can, they can prosecute, like, I don't know, it's not prosecute, abatement. That's what for nuisances and stuff like that, for ordinance violation.
Yeah, but those are administrative. They're not criminal. And they can only use it against city-controlled property. That's what nobody seems to understand. They can't create a law that affects private property and private persons that aren't on city property.
I just hope the 5th doesn't let them get away with what they're trying to get away with. They're messing me up again.
Well,
All right.
Jane, you're just too much trouble.
No, well, I'm already in trouble again. I already got, my neighbor's got the code enforcement after me. So on another situation.
Okay, let's look at a two-step reasoning here, okay, on why the city attorney has no immunity, prosecutorial immunity, and why they can't prosecute cases. Let's look at something here, and I'm going to show you exactly why that is. All right. First off, Article 5, Section 12 of the Texas Constitution. The presentment of an indictment or information to a court invests the court with jurisdiction of the cause. Who are the only public officials given the authority to make presentments to the grand jury and to sign indictments? And you will find both of these in Article 20 of the Code of Criminal Procedure, or Chapter 20. I'm sorry.
Isn't it the district attorney and the magistrate?
What do you mean, and the magistrate? How can it be the magistrate?
Isn't it because you have to have like probable cause determined
No,
first?
the magistrate cannot sign an indictment or information
Oh,
to charge someone,
yeah.
because then they couldn't adjudicate the case. They become the accuser if that was the case.
Well, then it would be is it the district attorney?
Notice here on the screen, requisites of an indictment. It shall be signed officially by the foreman of the grand jury. That's who can sign an indictment by law. The prosecutor can't sign it. Only the foreman of the grand jury can sign it. Okay? Now, let's go down to the next one. Requisites of an information. It must be signed by the district or county attorney officially. In other words, it cannot be signed by even an assistant county or district attorney. It must be signed by the elected county or district attorney in their official capacity. That's what's required for an information to be valid. What is required for an indictment or information to even be pursued and created?
Well, first you get the citation.
Nope. Citation's not a prerequisite for either of these two instruments. But what is? I'll tell you. Right here in the very next article. It must be based upon an actual complaint. Can't be based upon the citation.
That's what I was going to. Yeah, the citation is turned into a complaint, which therefore would be turned into an information, right?
Well, read what this says. No information shall be presented until affidavit has been made by some credible person charging the defendant with an offense. A citation doesn't do that.
No.
The affidavit shall be filed with the information. Well, guess what, people? The criminal complaint is not an affidavit. Why?
Because it's not sworn.
Correct. Because any swearing must be done under oath.
Yeah. So like what they say is the affidavit in my paperwork, for example, from Fort Natchez, right? And it says it's an affidavit, but you don't see it as signed as sworn under penalty and perjury.
Correct. And therein is the disconnect between what a complaint does and what an information or indictment does and what a sworn statement does. That's the disconnect. I have reason to believe and do believe is an accusation. That's it. A sworn statement has to be based upon first-hand knowledge. Criminal complaints are not required to be based on first-hand knowledge. Anybody that thinks a crime is being committed, whether they saw it or not, can swear out a complaint. But they only verify it upon belief, not upon personal knowledge. What our courts and our process have attempted to do in the state of Texas, and many other states for that matter, is to make a complaint appear to be as valid as a sworn statement. And it just fucking isn't. Anyone can accuse somebody of doing something wrong. But that accusation must be seen by a neutral magistrate and probable cause found by that magistrate to say this accusation is most likely true. It is most likely a crime that they're being accused of in the correct sense. And this person being accused is most likely the person that committed it. Now, there can be a sworn statement made to that effect, either by the judge finding probable cause or by someone with personal knowledge. This bullshit about municipalities and JP courts prosecuting on complaint alone with nothing else, especially no finding of probable cause, is complete and utter fucking bullshit. Because the existence of the complaint can never ever be the basis for probable cause. It just fucking can't. Because it's not sworn to under penalty of perjury, and the person swearing or signing it may or may not have personal knowledge of jack shit. We see that every single fucking day when the court clerk says, based upon information received from officer so-and-so, I hereby file this complaint. They have no personal knowledge of a fucking thing. So how can the complaint be the basis for probable cause? There's no sworn testimony given under oath to anything to back up the allegation. How can that be the case?
And the cop will sit there and argue with you and say, but I have probable cause. Not by yourself, you don't.
That's an assumption on your part and a legal conclusion, but it's not a fact. Not until a judge says it's a fact.
Right. Hence why I demanded to be seen by the magistrate. Was I taken? Not no, but hell no. I was thrown in a holding cell and booked.
Illegally.
Exactly.
Okay. Which is why you have a separate suit for false imprisonment, which you need to get filed. That suit, that clock keeps ticking, whether you're going to criminal trial or not. Because that is a separate cause of action that has absolutely nothing to do with the criminal allegation against you. That clock does not stop until you file.
And you say that's 2 years, right?
Nah, it depends. Some claims are 2 years, some are only 1.
Oh, I'm past.
Well, you need to find out what a false imprisonment suit, what the statute of limitations for filing it is.
Okay.
Eddie, you said a statement. You said that it's not something until the judge says it's a fact.
It's not probable cause until the judge says it is.
Oh, okay. That makes more sense. I didn't get that. Okay. Got that part now. Okay.
Eddie, when we have a moment, can we go through kind of a quick cliff notes of the process from actually being accused of a crime to getting to maybe the jury?
Define getting to the jury. Having a jury trial?
Having a trial, yeah.
Okay.
Wait a minute, Eddie, I was reading on the TMEC or whatever you want to call it.
TMCEC.
Yeah, about how they say that a municipal court can proceed with prosecution is because the judge in that court looks at the evidence or looks at the complaint.
They look at the fucking complaint. They don't look at jack shit before they go to trial, do they?
No, but so that
the
whole
TMCEC is supporting the current narrative, which itself is a violation of due process.
Right.
Okay? Their narrative violates due process, not to mention statutory and constitutional law.
They need to be challenged for sure.
Yes, they do. The state constitution says an indictment or information invests a court with jurisdiction, not a fucking complaint. The Code of Criminal Procedure cannot create an authority that supersedes what the Constitution mandates, or nullifies what the Constitution mandates, or alters what the Constitution mandates. It either complies with the Constitution or it does not. And if it does not, it must lose, because the Constitution itself is superior law over the statute, period. And any court that says otherwise is committing sedition from the bench, because they are attempting to overthrow a constitutional form of government and replace it with an oligarchical form of government in the form of the judiciary being in charge and making the law as well as adjudicating the law. And they can't fucking do that. And if they are doing that, then not only do they need to be challenged, they need to be fucking prosecuted. And we can make the argument that they stepped outside of all judicial authority when they violated the state constitution to do an act they are forbidden by the Constitution to do. See, here's their problem, which they don't seem to realize, and neither does anybody else that's trying to go after them for this bullshit. And I don't understand why, because to me it's a very clear ladder. So let's look at how this works. The court can never be invested with jurisdiction without an indictment or information, which they never get. They use the complaint all by itself. How can a judge be acting judicially when there is no case before them? There was never an indictment filed. There was never an information filed. Those are the only two things that can invest the court with jurisdiction of the cause. Therefore, the court, by definition, lacks jurisdiction, subject matter jurisdiction, and therefore lacks personal jurisdiction, as well as venue. We have now taken away every area of jurisdiction the court could possibly have by the simple fact there was no indictment or information filed. Therefore, there is no judicial cloak for them to hide behind, period, because they are absent all forms of jurisdiction at this point. They can now be sued in their personal capacity for impersonating a judge without lawful authority and prosecuting a case without lawful authority. The problem in doing that, no one's making the argument that way. They keep calling them a judge instead of Joe Asshole pretending to be a judge, but who couldn't possibly be a judge because none of the constitutionally required things to invest a court with jurisdiction were ever met. Not one. And because the court was never vested with jurisdiction, any action taken under the color of law as a court was by definition absent any and all jurisdiction. There is no bridge getting from A to B, period. And that, Jane, is why you can also name the municipal judge in your malicious prosecution lawsuit, because they were never acting as a judge either. But remember, in your pleading to sue them, never ever refer to them as a judge except for when they were acting under color of law to present themselves as a judge that had no valid jurisdiction in the first place. That's the only time you call them a judge, when they were acting under color of law and assuming the title of a judge that they had no authority to assume.
So, Eddie, question: which court would we be filing this suit in?
Well, you can file it either in a JP court as a small claim, or you can file it in the district court as a constitutional claim.
JP is small claim, right?
Yep, you're limited to $10,000 in JP.
But if we went to district, that would be a much higher claim.
It could be limitless. You can ask for any amount of money.
20,000 in JP court now. It's been since 2021.
Well, again, a statute gave that limit. The Constitution actually says $100, period. The state constitution says if the amount is in excess of $100, they can't hear it.
So then your best bet is the district.
I'd go for maximum money regardless.
Yeah.
And again, you can sue them twice, state
Right.
and federal, but you
But
must
state
be
and
very careful to separate the claims only into state
Right.
authority versus federal authority.
So in the state authority, you were only arguing the state law and
the
our
state constitution.
Constitution.
You will never ever cite Sixth Amendment, Fourth Amendment, 14th Amendment.
No, none
of that.
No.
You will only cite Article 1, Section so-and-so of the Texas Constitution and the Bill of Rights.
And then you can use Texas case law to back it up.
If there is any.
If there is any.
Okay.
Now,
but again, you don't have to start. You're not going to find case law to back up 90% of what you're going to do in this, because nobody's making this argument to get them on the hook for it.
Yeah. And
the only one you're going to find the false imprisonment part 4 and the malicious prosecution part 4 are the cops. That's the only case law you're going to find, because nobody has gone after the fucking city attorney and the city judge by claiming they were never elected officers who had the cover of constitutional protections and immunity.
See, that's the thing, though, since us now turning into plaintiffs and then defendants, we have to be extremely, prepared and cleared with all evidence against them to show that they did indeed act outside
if you
of their
have a complete copy of your court record with all of their signatures on orders, their signatures on proceedings, all of the administrative records, you're not going to get all of the records. You're only going to get the adjudicated file. So you would have to file for discovery to get the administrative records that the judge did behind the scenes and signed to show that the judge was acting without lawful authority.
Yeah,
And
but
they
he
were
didn't
acting
sign
in their-
jack shit at the lower court. So then what do you do when he said, I'm not a court of record?
They had to sign the judgment. And the judgment is a judicial function. They had to sign the judgment order or it's not enforceable. But don't forget, guys, there's also Title II of the Code of Criminal Procedure, which they never comply with. Title II specifically requires that with the judgment, they must submit a signed, itemized bill for every single thing they're charging you for. And they never, ever do it. And they're not allowed by law to collect 1 cent of that money until that itemized bill has been presented. Yet, if you don't pay it right away, they issue a warrant and throw you in jail until you do pay it. So once again, another false imprisonment suit on top of it. Because the law is very clear, they had no authority to do what they did because they never submitted the itemized bill. Therefore, they couldn't collect. And until they do that, they have no authority to issue a warrant to put you in jail until you pay. Everything's connected if you just go find where the dots are and then figure out what picture they're meant to draw. That may not always be obvious, but it can be figured out through trial and error. When you start connecting the dots and something doesn't look right, then you look and see if you missed a dot or misallocated a path somewhere and go back and fix it till you get the correct picture. And then you can use that picture to fucking brand them with. All right, anyway, the first step is the information must be based upon a complaint, and the only person that can sign an information in their official capacity is a county and district attorney, not a fucking city attorney. Which is why they say the statute says that a city attorney doesn't have to file an information, because they can't fucking sign it. But the problem is that turns around and violates the Texas Constitution. When you look here, the presentment of an indictment or information to a court invests the court with jurisdiction of the cause. Doesn't say a fucking complaint does that. It says an indictment or information does that. Then you go over here to Article 5, Section 21, and it tells you, the county attorney shall represent the state in all cases in the district and inferior courts of their respective counties. What courts are inferior to the district courts?
Is it county and statutory?
That's correct. County courts at law, the constitutional county court at law, and justice and municipal courts are all inferior to the district court. The Constitution didn't enumerate all of them. It simply says that since it gave the legislature the authority to create courts by statute, they knew that they couldn't list specific courts in the Constitution. They did know that the courts that were created by statute had to be inferior to district courts. So what they did was, any court that is not a district court and is below the district court shall be called an inferior court. That makes the Constitution consistent,
You made
not incomplete.
Yeah, you made a lovely printout about that.
Okay? So, the county attorney shall represent the state. Shall is a fucking command. Not an option, not permission. It's a command. The county attorney shall do this. However, but if any county shall be included in a district, in other words, you have a district which encompasses multiple counties, and then you have the individual counties within that district. Okay? So if a county is in a district where there is a district attorney, the respective duties of district and county attorneys shall, in such counties, be regulated by the legislature. So, the duties of the district and county attorneys, which one of those is a city attorney?
None.
None. Where's the city attorney appointed as a branch or subsidy of the district or county attorney's office?
None.
There is no such appointment. There is no such allocation. Doesn't fucking exist. So how then can they be acting in lieu of a county or district attorney when they have no association with their office whatsoever?
Simple. They can't.
They can't. So the legislature is not given the duty or the power to regulate city attorneys as being part of the county and district attorney's offices because they're not. They can only regulate the duties of the county and district attorney themselves, but they must do so in a way that harmonizes with the Constitution. And the only way they can do that is by making sure that the county and district attorney are the only ones who can prosecute in the name of the state, because that's what the fucking Constitution says. And only the county or district attorney can sign one of the instruments required to invest a court with jurisdiction. And only the county and district attorney can make the presentment of a case to a grand jury to do what needs to be done to get the indictment. Now, the grand jury can do its own investigations. They can look into its own complaints by any of its members. They're given authority to do that, both by Constitution and by law. But a city attorney cannot present to them. A city attorney cannot seek an indictment from them. A city attorney cannot sign an information. So how can there be any authority for a city attorney to prosecute in the name of the state and that authority be legitimate? It can't.
Can't.
Because it violates Article 5, Section 12 on what's required to invest a court with jurisdiction and who must sign it, and it violates Article 5, Section 21. Okay? But there's one other one to take into consideration, and that is Section 17 of Article 5. The county court shall hold terms as provided by law. Prosecutions may be commenced in said court by information filed by the county attorney or by affidavit, as may be provided by law. Grand juries impaneled in the district court shall inquire into misdemeanors, and all indictments therefore returned into the district court shall forthwith be certified to the county courts or other inferior courts having jurisdiction to try them for trial. So here we go. A twofold example of why an indictment is still required even in the cases of Class C misdemeanors. Fine only. Okay? Grand juries impaneled in the district shall inquire into misdemeanors. Do they classify the Class C as a misdemeanor? Yes, they fucking do. Class C misdemeanor. Okay? So, the grand jury shall inquire into a misdemeanor. Doesn't say unless it's a Class C. Doesn't say unless it's a malum prohibitum. It says shall inquire into misdemeanors. This is why the Bill of Rights, Article 1, Section 10, used to read that no person shall be tried for a crime except upon indictment by a grand jury. All indictments therefore returned into the district courts, and we know that they do it for JP courts because Article 5, Chapter 21 of the Code of Criminal Procedure says they do. So let's go back over here real quick to the Code of Criminal Procedure. Causes transferred to justice court. Causes over which justices of the peace have jurisdiction. And remember where this is. 21.27. May be transferred to a justice of the peace at the county seat, or in the discretion of the judge to a justice of the precinct in which the same can be most conveniently tried, as may appear by memorandum endorsed by the grand jury on the indictment, or otherwise. But it must be endorsed by a grand jury. Order transferring the case. Upon the filing of an indictment in the district court which charges an offense over which such court has no jurisdiction. District court only has jurisdiction over felonies. Okay? If there is no county court at law, then the district court would also have Class A and B misdemeanors. And if there is no municipal or JP court, they would have jurisdiction over the Class Cs. But that's only if none of those other courts exist. And I don't think there's any county anywhere that doesn't have at least one of them below the district court. Okay? So, the judge of such court, meaning the district court, shall make an order transferring the same to such inferior court as may have jurisdiction, stating in such order the cause transferred and to what court transferred. And right here it says, when you're sending them to a JP court, cause is transferred to a justice court. There is no statute for sending them to a municipal court. None. Abso-fucking-lutely none. They cannot transfer a case for which there is an indictment or information to a municipal court. Ever. Okay? Because there's no place in law for them to do it. So, if it appears to the judge that the offense has been committed in any incorporated town or city, the cause shall be transferred to a justice. Once again, justice of the peace that is within the city limits. So there must be a JP precinct within the territorial limits of the city for the judge to transfer it to. That is not an authorization to send it to the judge of the incorporated court. Why? Because it doesn't say that it's send it to the municipal court. It says to a justice, which it's clearly stated right here is a justice of the peace. See this? Justices of the peace. Okay? So it has to go to a justice in said town or city, if there be one therein. And if not, then it still goes to a justice in a precinct outside the city. And any justice to whom such cause may be transferred shall have jurisdiction to try the same. So right here, you have between the Code of Criminal Procedure and the Texas Constitution irrefutable statutory fucking proof that a city attorney and a municipal judge have no fucking authority to be prosecuting these cases. None. And neither does a JP without a signed information or indictment. Irrefutable fucking proof. And then it goes into all the things they have to do once that case has been transferred to one of those types, to a JP court or to a county court at law. So you see how they managed to take the law and just ignore what the fuck it says and thus deprive themselves of jurisdiction to do anything they're doing? The moment the judge acts outside of the legal requirements, they are no longer acting as a judge. Because when they use the word shall or must in the statute, that creates what the law calls a non-discretionary duty. In other words, do this or else. Well, we are going to hit them with the or else part because they ignored the do this part. And when they did that, they stepped outside of their authority as a judge or as a prosecutor or as any fucking thing else and acted entirely as an individual without any color of law authority to do it. Because if they're acting outside of the law, they cannot be claiming to acting under color of that law. Well, they can, but it won't shield them because it's obvious that they aren't. They're using the color of the law, but not the actual obedience to the law. So draw that distinction. Color of law versus acting in obedience to the law. And that's how I'd word it in a legal pleading. The court chose to act under color of law rather than through the authority vested in the court by the law, and ignored a non-discretionary duty created by statute and the legislature for this specific procedure, wherein the court did A and the court was required to do B.
And you can argue this too in a judicial complaint against the judge.
Yes, you can.
And against the prosecutor in a bar complaint.
Yes, you can. But this is why the first thing I'd file is a motion for a vote of no confidence in every court they try to put me in a criminal case. Every court they try to put me in, one of the first motions I'm filing is a motion of vote of no confidence. And here's why. Here's all the case law that shows how they're doing things. Here's the Constitution and the actual state law that says they can't do it that way, and yet they are doing it in violation of both. Therefore, I have no confidence in their ability to either properly interpret, apply, or decide anything about the fucking law. Who are they going to get to try you then? When you've disqualified every fucking high court in the state because they're the ones that set the precedent that allowed the lower courts to violate the fucking law and the state constitution.
And as always, they'll just say overruled, denied.
Then we sue them in the federal court. And we take away their immunity by showing that they were not acting as a judge. When they acted without legal authority, they stepped outside of their cover as a judge and acted as an individual exercising authority they did not have. Hence, we sue them in their official or their personal capacity, not their official capacity.
So what we're saying is it's their personal choice to act that way.
Well, it's always a personal choice for them to act that way.
Yeah.
And
But they'll try
this
to
is what I keep trying to get you guys to understand about what is so wrong with bar associations even existing, much less being the ones that decide who gets punished and who doesn't. The people who are breaking the law are the ones that are deciding whether or not they're guilty of breaking the law. That's a problem. Or it's being decided by people who want to be in the position they're in one day and don't want to be held accountable in the way we're trying to hold these people accountable, and thus they cover for them. Same problem, different people. Different approach. Still the same problem. This is exactly why I argue no branch of government should ever be allowed to investigate or hold accountable any other branch of government or department in that government. Every single thing should go through the people, and people created and presided over committees, period. The people should decide whether or not their government is doing its job properly, not the fucking government itself. Until that happens, we have no accountability. At least nothing that will be consistent. I mean, right now we need a constitutional amendment that makes it a crime for any public official in any capacity whatsoever to ever refer to the United States and the several states as democracies.
Now, I think that Dave has argued that a bit, that it is a democracy.
No, it's a democratic republic, but it is not a democracy.
Yeah. I think he had a little argument about that, but again, I don't recall all the details, but I do remember him mentioning it.
Yeah, it's
not a democracy.
They're acting like it's a democracy, but it's not.
It's not.
When they start expounding on public policy being controlling, now they're acting like it's a democracy, because the rule of many overrules the rule of one, which a republic is specifically created to prevent. My rights disappeared because the majority said so. That's a fucking democracy.
They're trying to absolve it to become that. That's basically what they're doing, is absolving and abrogating what was originally put in place for this exact reason. Because our founders knew that the people coming before or after them were going to try everything in their power to destroy everything that they worked so hard for, to prevent us from falling under the same demises that occurred back in Great Britain and the European nations when they came over here to escape that stuff.
Well, every state should have a constitutional amendment that it is immediately disqualifying. You are immediately disqualified from holding public office if at any point during running for that office or holding that office, you refer to the state you're elected from or any part of our government as a fucking democracy. You do that, you're gone. No ifs, no ands, no buts, no leeway. You're gone. Because you obviously have no business operating in our government when you don't even understand what the fuck capacity you're supposed to operate in.
And none of these elected officials seem to understand any of that. And there
are lots of them that'll tell you they understand it.
Oh, yeah. But
until they're giving a fucking speech and they say it as it's a democracy.
Yeah. And we have to remember that they're paid for.
That's something you will never ever hear a Democrat ever say. They will never call us a democratic republic or a constitutional republic. Never. They always use the word democracy. Always. And most Republicans, the rhinos, do it too. And a lot of the conservative Republicans supposedly do it as well. Hageman and Mace are one of the only, and Gabbard, they're the only ones that I've heard in recent times, and Kennedy, refer to us as a democratic republic or a constitutional republic. They're the only ones. All the rest of them call us a democracy. And even Kennedy calls us a democracy from time to time.
I heard a good percentage visualization. 51% can control 49%.
Yep. Well, actually, 50.01% can control 49.09%.
I'm trying to figure out a good phrase to wrap people's head around that. Yes, we have democratic processes, but
Mob rule. That's the phrase. If whichever side has the highest numbers wins. Period. Doesn't matter if that number's 1 more or 50 more or 5 million more. Whoever's got the majority wins.
but they seem to miss the point. No matter what the majority is, you still have rights that nobody can overrule.
Right.
And I don't know how to get that across people's heads.
Well, then you have to give them an example. In a democracy, 3 guys standing around, one of them owns a bike and the other 2 only can walk. However, the other 2 get together and decide they want the 3rd guy's bike. So they beat him up and take it. Congratulations, you live in a democracy. Majority rule. Okay? However, in a Republican form of government, the guy with the bicycle has the right to defend himself against the other 2 guys on foot, and if necessary, beat them to fucking death to stop them from taking what's rightfully his and harming him in the process. Welcome to a constitutional republic.
That's a good one.
Amen.
And in the democracy, the guy that had the bike originally has no legal recourse or ability to recover his property or demand restitution or anything else. He's just fucked because it was 2-1. That's a democracy.
Kind of sounds like where we live today almost, doesn't it?
Almost. All right. So everybody see how I connect the dots to make the arguments I'm making about why the things they're doing are actually a violation of rights and due process? Number 1, they're not complying with the Constitution. Number 2, they're not complying with the laws promulgated under that Constitution. And number 3, they are acting arbitrarily under color of law with no actual lawful authority supporting what they're doing. 3 fucking strikes, you're out. That's what I meant by it's a very clear ladder to me. All right. Any other questions, queries, comments, complaints, bitches, moans, groans, or anything of that nature?
Lots of them. Let me know when I can jump in.
Jump.
Quick one, 12B6 has anybody addressed the overuse of this?
Well, define what you mean by overuse.
Well, it's so commonplace that nobody even questions
Well,
the fact.
it's automatic. It's something everybody's going to do. Everybody's going to challenge why this case should not be allowed to go forward. Any smart person would. Nobody would sit down and go, yeah, just go ahead and sue me or prosecute me or whatever.
Well,
I'll take my chances in court. No, if I can get rid of it before I ever have to set foot in court, that's what I'm going to do.
Okay, let me get to the merits of that question then.
Okay.
If they file a 12B6 knowing that the case actually has a chance, has claims, because the whole point of a 12 motion, right, is the fact you have no grounds for a claim that can, with relief which can be had, yes? So,
well, for each cause of action you're trying to claim, yes. They have to prove that your claim is without merit in some way. Either because you failed to properly state the claim, or there's an immunity involved that you cannot overcome, or that there's no legal basis for the claim and no evidentiary support for the claim. They can come up with anything they want. They're not likely to use the last of those 3 arguments because those would be jury questions. Is there a law? And is there evidence? If they go to that, they've pretty much agreed with you that you have a case for that claim. So they're always going to try to go, you didn't make a claim that anybody could reasonably understand and thus pay you off for, or we have immunity from that kind of claim because they go to the third one, they're making an admission they don't want to admit, therefore they won't.
Well, I'm seeing both of what you're saying there. I'm seeing actually some admission, but I'm also seeing such a casual assumption.
Well, what you're seeing is a deflection. And even if A were true, B prevents this cause of action or this claim from being valid because that's a deflection. What they're trying to say is, yeah, this part of it, the claim is true, but if this part isn't also true, or this part is in opposition and negates that part of the claim, then you still have no claim at all.
Okay. Quick example, because I talked to an attorney about this. He said file a Rule 11 of sanctions. Did I mention this last time?
Yeah. Well, I don't know if you mentioned this, but your attorney's correct. What you can do is if they can abuse the 12b-6 by intentionally misstating the facts of the case, intentionally trying to mislead or perpetrate fraud upon the court by making claims they know to be false, or using rebuttal facts and evidence they know to be false. Any of those things that you can refute and prove they did, that's grounds for sanctions.
Okay. I just read the Rule 11, and I have to give them notice in 21 days to correct their errors before I can actually file a motion.
Yes, you have to give them a chance. What you have to do is say, look, I caught you in a lie, this specific lie. Now, you either fix your lie, or I'm going to ask the court to kick you in the nuts because of your lie.
Okay.
Now, should you have to do that? I wouldn't. No. If someone's going to throw dirty punches, they ought to be able to be held accountable by the referee instead of the other boxer having to step up and go, you hit me kind of low on that other blow. Don't do that again. If you do, then I'm going to complain to the ref. That's fucking stupid.
Yeah, I agree.
And here's something I was thinking about today. When you really look at the way our judicial process is set up, it is designed to do one thing and one thing only. Extend the litigation process to generate as many fines, fees, and billable hours on both sides of the equation as it possibly can. In other words, it's designed to benefit the fucking attorneys, not the individuals.
Yeah,
not the clients.
Yeah.
That's why
Okay. I mean, let's think about that from a logical standpoint. Okay, Chris, let's say you've got 6 claims, okay? And, well, actually, you've got 6 issues that back up a single claim, okay? And let's say you only have the one claim to make and 6 different ways to get there. All right? The way the courts do it is if they can find just one of those 6 to get you there, that's the only one they rule on. They throw the rest of them aside and say, we don't have to respond to these because this one got us to either this point or that point. Okay? Like the immunity claim. If immunity exists, your claim is dead. If immunity doesn't exist, then they have to go to the next one in line to see whether or not that one holds water. Right?
Okay.
All right. So, however, let's say that immunity gets shot down right off the bat, leaving your 6 claims or your 6 avenues in, that even if A was true for the defense, B would kick in, et cetera, et cetera, et cetera. But if at any point they decide A will get you there or B will get you there, the rest of them remain untouched. What the court is doing is leaving those questions of legality open for someone else to have to come back and adjudicate, rather than answer them now in the either or proposition that you put up there for. If they would decide all 6 of those issues right now, that would become the opinion that set the stage for everybody else that follows behind you that can rely on any one of those 6 things to make their case fly. But the courts don't do that.
They can't do that.
Sure they can. Why can't they? They can sit there and say, okay, the plaintiff succeeds on their first argument right here about why they should be allowed to go to trial and initiate this claim and have it heard by a jury. Great. But let's see if their other reasons also have merit. B says this. Yes, that too would get them their claim. So let's check C. C, yep. All right, that one holds water too and would get them to their claim. If the court went through each one of those and said, yes, these are all valid ways to get to the same claim, then the plaintiff or the defendants could no longer use the 12b-6 to sidestep the ones that weren't addressed.
So you're saying they take the easy way out just by doing one?
Exactly.
Okay.
So that they can have fees, fines, and revenue coming back in for somebody to eventually address one of the others. It's how they prolong and continue litigation over issues that should have already been settled because they were raised.
Yeah, and my husband said like the other day, he's like, well, why are they resetting? Again, this is like the upteenth time. Why the hell didn't they just listen to the damn arguments and rule right then and there? Why did they have to keep bringing you back? And
because
it's not
the goal is not to listen to your argument, is to make you give up.
Right, and I'm not giving up. No, I've crawled this far, honey, I'm going all the way.
But see, this is where a motion for speedy trial would have prevented them from playing that card. Without that motion for speedy trial, they can do this forever.
Let them.
Okay? That's the problem.
I don't think you can ask for a speedy trial in federal court, can you?
Yes, you can. You have a right to a speedy trial in any court.
Yeah, okay.
Will you build that out just a little bit? When do you need to file a motion for speedy trial? How soon? Before
as soon
trial?
as you fucking know you can win your case.
Okay.
For instance, if you did everything possible to be prepared for the day you got a traffic citation, for instance, and you know exactly what your argument's going to be, you know exactly how to defend it, you know exactly how to beat it, one of the very first things I'm filing is my motion for speedy trial.
Can you do that after the indictment itself?
You can do it anytime you want. But the speedy trial clock does not start ticking until you've done it.
Roger. Thank you.
Mm-hmm.
So really, it's kind of late to be sending in that motion.
It's not too late, but yeah, you're a year in.
Yeah.
So if you
How
file
would
it
you go
now,
about-
you're going to push them into having to do it. But, you know, the question is are you prepared? And that's the reason why most people don't do it. They think if they just let it languish, that it'll go away on its own. That they won't have to prepare. They won't have to write. They won't have to do anything except just pray it doesn't happen.
So how would you go about getting that accomplished in federal court?
What do you mean, how would you do it? You would file a motion demanding a speedy trial for your case, whatever the case is. Now, the question is, I believe the right to speedy trial exists both in civil and criminal.
I'll have to look up on Federal Rules of Civil Procedure, see what it says.
All right. Anybody got anything else?
I got a question relating on some of the videos I listened to. You've already talked about how you get the officer's body cam or dash cam footage into evidence for the trial. What about if you have your own recording that you took with a recording device? I.e., in my case, I've got an audio recording that I took on my phone that I may find necessary if I can't get the body cam or dash cam footage from the officer.
Well, then what you can do is you can certify that to the court that this is a recording I made at the time at the stop, and I provided a copy of it. Now, you will have to give the other side a copy of it prior to trial so they can review it. And you're going to have to sign an affidavit stating what it is. And you may be called to testify to exactly what its contents is, but make sure that when you say, I am willing to provide limited testimony as to the source and time frame of this recording and nothing else. That if they swear you in and put you on the stand, yes, I made this recording on this date at this time for this event. And that's all you say. And then, well, you can also say, and the recording contains audio from this person, this person, this person, and this person. But you don't let them take you anywhere else. You do limited testimony, and you couch it that way. Judge, if necessary, I am willing to take the stand for a very limited interrogatory regarding the time, place, and who's responsible for making this recording. Myself. Time, place, and the individuals recorded. That's it.
And
I'm not willing to answer questions relating to anything else.
Okay, perfect. Thank you. And then in a separate, this would be relative to civil, short background, just personal property taken by a neighbor that didn't have rights to take it. I'm going to send them a demand letter to start the process. Well, it is, but the district attorney refused to prosecute it because he said it was tied to previous civil case. This was the people that basically defaulted on the loan that I made them for property they bought from me. And then when they were clearing their stuff off, they had shipping containers that I had sold them, but I still had my property in it. They took off with the containers with my property with no notice. The DA refused to prosecute it. So I've got to take it the civil direction now. First, I've got to give them the opportunity to return my personal property.
Right, and that's why it's still in the realm of civil.
Right. And so I'm going to file a demand letter to bring them into that. Any thoughts on how many days I can give them to return my property? Is it 14 days, 21 days?
I don't know. You're going to have to look at whatever your state law is.
Okay. Okay.
I'm sure it's not more than 30.
Okay.
But I can't tell you what the minimum is.
Okay. I'll look that up. Would you find that in statute and state law or in civil procedure? Or, yeah. Okay. Thank you.
Now, there may be case law and in your area that sets it that the statutes don't when it's a civil matter. Okay. But if it had been a straight up criminal matter, see, the problem there is you have a mixed bag. They're storage containers, but your property's in them.
Yeah.
Okay. Now, did you have locks on the storage containers?
I did. Yes.
Okay. Which they couldn't open, right?
Correct.
Therefore, they couldn't right, and they couldn't verify what the contents were without damaging the locks, right?
Correct.
So, they simply took it as is. Now, the question is if they had abandoned them there for whatever the amount of time is your state law requires for them to be considered abandoned, okay, then yeah, it's civil to sue them to get them back or to charge them for the storage and the return of your property. That part the district attorney's got absolutely correct. Because they took their container, the fact that your shit was in it and they couldn't verify whose shit was in it, that doesn't really fall on them when they didn't have access to the interior, right? They just knew the container belonged to them.
Well, they were noticed and aware that I had property.
I understand that, and that's still a civil contest. That's not a criminal contest.
Right. Understood.
Hence the reason for the prosecutor doing what they did. And then under the gold button that says make a donation to Eddie, that's what you're going to have to click on for me to actually get it. If you go through any other way, there's no guarantee I'll see it.